Welcome everyone. My colleague Rebecca Trobridge and I will be presenting tonight about a program helping people with neighbour disputes. Before you make the complaint to council, make a call to a mediator and see whether or not things can be sorted out. I'm Joanne Law, I'm the Director of Mediation Institute and co-founder of Interact Support, the not-for-profit that we run this program through. And Rebecca, would you like to introduce yourself?
Hello, everyone. I'm Rebecca Trobridge. I volunteer for ICDRS. I also work for Hunter Community Legal Centre, so I do see what the other path would be if you don't take mediation. I also am on a couple of state farm debt mediation panels.
Well, thank you. And I will introduce virtually.
My name is Matt Lockwood, and I'm in the Adelaide-based mediator here at the Adelaide Magistrates Court, and I have a private practice as well, and very involved in community mediation through ICDRS. Who is ICDRS, and why are people like us talking to you today? I'm the help up where we like to help people, and our unique skill set is this stuff, helping people in conflict. And the feeling we get of walking out of a mediation when two people or a group of people have worked out a path ahead after sometimes years and years of ongoing conflict, the mischiefs associated with that, well, you can feel it and you can see it. It's like there's a weight in a room like this. And for us, we love it. We specialise in this skill set, and this is what we like to practice. Joe and Beck are going to share a little bit more about ICDRS and how we're trying to match the benefits, quality and professionally registered mediation services, matching that skill set to the problems in our communities that we see arising from unresolved and poorly managed conflict.
Excellent. Thank you, Matt. Matt wasn't able to join us. He's one of the co-facilitators of our program. A little focus why we do this work to help people to communicate and sort out their issues through mediation, particularly in this area that we specialise in community and neighbour disputes. And it's because ongoing conflict is harmful. Mediation is safe, it's empowering, and it helps people to find solutions that last. And compared to using lawyers and going to court, it's certainly a lot faster and more affordable. The mediation program is very affordable because it's free. We have some other low-cost services. I'm going to hand over to Rebecca, who, as a lawyer and working in community legal services as well, has a pretty good insight into that other side where people go straight to have conflict, have an issue, got to call a lawyer, and they go down a certain path.
I think of the choices that we have in front of us when we're faced with conflict as choosing a blame or an aim mindset. When we have a client that is in a dispute, we do ask them at the legal centre what it is they want. And so we will get some clients that say, I want to basically get justice. It's all about who was right and who was wrong. And if that is what the client wants, then basically they want to get in front of a judge who will decide who was right and who was wrong. Okay, so that means court is their path. They're not really interested in a way forward. It may be that in the future they don't have to have a relationship with the other party. However, nonetheless, even though you might choose court as your path, the judge can at any time call for mediation to be done between the parties. And so even when making a decision about who's right and who's wrong, the judge looks at the behavior of the parties. Did you actually try to work it out yourself? Did you try to negotiate? Did you go to mediation? And how well did you communicate with each other? So that actually gets factored in when the court is deciding who's going to be successful in the case. Now, it may not be a major part of deciding it, but it is one of the mitigating factors for a case for one of the parties. So in the end, it does come back to mediation anyway, even if you choose the blame mindset, which is fine. The aim mindset is if you want a working relationship and then you have to focus on the future, then your preferable path is mediation. So we then tell clients that if you are going to go and negotiate in good faith, which is what mediation is, You need to focus less on the history of the dispute and really think about what you want, and to balance that with the needs and the wants of the other party as well. Okay, let's just take, I've got a couple of examples, just looking through some court cases with the New South Wales Land and Environment Court. My apologies to people in other jurisdictions. So we have as example Foster v. Norris. So if you look at these photos, you can see there's a fig tree that is impacting on the roof, the corrugated iron and the gutter of this part of the dwelling, and it's actually on its way to crushing it. That pretty much, the person who's building that is pretty much thinks that they have an open and shut case. The neighbour's tree has come over onto my land, has pushed over the fence and the retaining wall, and is now doing damage to my property. I'll tell you the outcome in the next slide.
But what do people think?
Yeah. Does anyone want to hazard a guess as to what the outcome was? Or what would you have thought if you were the judge? What would you think? If you go to the next slide, we'll have a snapshot of what was decided, which was Foster, whose dwelling that is, had to pay for the pruning of Norris's tree. Because now, if you look at the judgment, it's a pretty long judgment, and the magistrate looked at a whole bunch of factors, many, many variables. And the two that were the most pertinent were the fact that Foster had moved in knowing that the tree was next door, and also that dwelling had not been built according to approved plans. So therefore, the person who's building that had to pay for the pruning. And once this was decided in the Land and Environment Court that it was actually partially Foster's fault, then that does affect how likely they are to get, if they decided to go to local court and say, yeah, I want someone to pay for the actual damage to the dwelling, the decision of this case has affected their ability to get any further payments relating to this specific damage. Of course, they're going to have to pay for 50% of that fence. The fact that the fig tree pushed it over, according to the person that decided this, it was partially the fact that the fence and the retaining wall were not built properly either. So then it wasn't the fault of the fig tree pushing it over, even though if you can see it's such a large fig tree, but this is the reasoning of the magistrate, and it's very detailed and they go into many variables. So you can never, ever guarantee the outcome. So let's have a look at another happy story. And look, I didn't go through cherry picking disaster stories to make mediation look good. I just randomly went to jade.io 2025 noise and just found, like, it took me like 5 minutes to find this case. Okay, so let's look at noise. You can see here we have a picture of a rural zoned low density residential area. You've got Ms. Roddy and Ms. Quilty, the neighbours that are complaining. In that yellow border area is the land, and that star is where the shed is, where all the noise is emanating, or most of it. And so those two neighbours kept noise logs and submitted evidence of banging, grinding, pneumatic tools, amplified music, parties and fireworks on Friday nights. There was one night where the party went from 10 p.m. till 5:30 a.m. in the morning, and the use of dirt bikes and a recreational vehicle. And when council came over and visited, oh yeah, so it says here 1 to 8 hours duration, sometimes all day. When council visited 3 times, 2 of those times they actually saw the quad bikes being ridden and made to backfire repeatedly, like made to backfire like a gunshot, because clearly these people didn't care that council was coming to visit. So they're just happily making noise all the time. You would think that was also an open and shut case. Wait for it.
Much, yeah.
So basically, even though we also get complaints, by the way, just as an aside, at our CLC, neighbours complain about council doing nothing. Well, in this case, council did do something. They just didn't observe proper evidence gathering according to the commissioner that decided this. There were actually 9 noise receptor sites nearby that these 2 neighbours could have also provided more evidence for, that council could have gathered evidence from. Council didn't provide a background noise level with which to compare the disruptive noise to. The commissioner also go through the law with a fine-tooth comb, went and looked at the meanings of offensive and compared it to the meaning of intrusive. The noisy neighbour got a noise expert who basically said that technically this noise isn't offensive. The neighbour Dune, who was issued with a notice to stop making noise, appealed it and his appeal upheld. So he now basically can make the noise that he was making before. So as you can see, Commissioner Dixon says here, yes, I understand that this is irritating and disturbing. She does say, yes, this is annoying. I get it. However, he's allowed to do it. Moral of all the story is that taking that path, the court path, sometimes it just can land you back to square one, where in the end, it's best to try to have some kind of relationship with your neighbor to start negotiating. Because at this stage, now that we've got court basically saying they're allowed to do whatever they want, you're going to pay for the pruning of the tree. Now you have some hostility already between you. You've got one of the neighbors now saying, I can do what I want. I don't have to listen to you. And you're just a party pooper. And I don't want to talk to you. So then any chance of maybe even trying to negotiate together are even less. That's what I imagine after court, dragging each other through the stress and the pain of that. So that's just some horror stories. Thank you.
Thank
So
you.
we'll go to the next one. And so, yes, you know, when I do get calls at the legal centre, we all can handle a certain amount of conflict. So at the point that we start getting calls, I would say a few of them are already deeply hostile. They've already researched their rights. They're now starting to call legal centres, or we would refer them to private solicitors as well. We refer them to ICDRS, but we also refer them to private solicitors depending on how they want to go. It is true what this says here, that if there's an earlier conversation that isn't hostile straight away, because once it reaches council, police, or courts, it becomes hostile pretty quick. What we have seen, though, is sometimes by the time ICDRS gets contacted to do a neighbour dispute, the hostility is quite entrenched, that the other party doesn't trust that ICDRS would be neutral or that it's there for the benefit of both parties. And so they're not even interested in mediation, or not even interested in having anything to do with the other party. And so I like to think of it as, if we start off by meeting the conflict in peace, and so this is a good story where two samurai meet to fight, and they see in each other's eyes their intentions, their years of intense martial arts practice, and they can already see the blow by blow outcome of the fight that's upcoming. They already can see it. And so once they see it, the fight is already decided, and the two samurai part ways without a single move made in violence. So in that sense, you can have, if people still want to have it hashed out, it can still be done in mediation. It just doesn't need to go through all the stress and the expense.
I was just going to say, and for us as professionals working in this area, we know about the blow by blow, but it's often very difficult to communicate to people who are coming fresh into a conflict. So that's part of what we're hoping to get through. But I did see, Nalika, you put your hand up before. Did you have a comment or a question?
I was going to ask, yes, the litigation or the adversarial process, that could be like, any outcome. But what is the, other than the mediation, what are the remedies available to these parties then in legal sense?
Yeah.
I mean, the intention and the knowledge is the main factors in those two cases. So then,
yeah, the challenge, and Rebecca will be able to answer this better, but the challenge is there's always two experts or various evidences and a range of different perspectives that the specific judges or magistrates or whoever. So that the lack of certainty is one of the bigger factors. But Rebecca, you might like to.
Yeah, damages can be hard to quantify as well. Just being annoyed and not enjoying your private enjoyment, usually that's where all that can be done is to get the other party to stop. And that's what you're really hoping for. Stop the tree growing into my side of the fence. Stop you from making noise. Stop your dogs barking. Other than getting them to stop, there's really not much scope for getting recompense unless you can actually quantify how much the damage that annoyance has cost you. And then as you just understand that even though you're putting forward the evidence of those damages or the effect that has on you, that will also get scrutinized in court. Okay, so the other side has the opportunity to cross-examine you. The other side has the opportunity to go through all of that evidence and look for where it might fall down. It really is a game of whose evidence is better than who, like, which is what you said, Joanne. You can have two different experts saying two different things.
Yeah.
So,
and ultimately someone making a decision that you have to live with instead of you making the decision of what you can live with.
exactly.
There is a financial cost. So getting experts, they need to be paid for their time, and professional liabilities, lawyers need to be paid for as well. But there's a lot of non-financial costs that people bear with conflict. So stress, sleepless nights, anxiety. Often people talk about the loss of sense of safety and comfort in their own home. They scurry in and out from the car because they don't want to see the person next door. And certainly that escalation. So complaints that stop the building progress as they're trying to get the granny flat built, all of those ongoing things, the social media rants in the local community Facebook group and all the wonderful things. And then, of course, the legal letters, police. In the community area that we work as well, something that really concerns us is for volunteers, because there's good evidence about the health benefits of volunteering and being part of community. When conflict doesn't get resolved, generally people will leave and lose access to their community or sporting or whatever club. Calling the police is a pretty common response as well. Things start to get a little bit heated. We did a little bit of research. These are the top triggers in Australia for neighbour disputes. So noise and lifestyle differences. And we've seen an example that made it all the way to the court. Loud music, dogs, renovations, someone doing lots of welding, grinding, fences and boundary disputes. So very common about who's going to pay, what it should be like, what colour, locations, trees, roots, overhanging. So all of those sorts of things are pretty common. Parking, that can be a really big source of annoyance for people. They don't think that person should park there, particularly in community. A lot of dwellings have very small amount of space. So these are the sorts of things that we need to deal with. Pets coming out, being frightening, and so on. Renovations not done thoughtfully, thinking about how they're going to affect the neighbours, creating new water channels and paths that suddenly start flooding people's patios and houses and what have you. Yeah, so by a show of hand, who's ever been frustrated by any of these things from a neighbour? You can use your fake hands. Yeah, absolutely. And rudeness and disrespect, it's kind of down the bottom, but it's generally a factor of the others as well. So they come in. This particular source, Real Neighbour report. But good news is almost half did resolve the issues by speaking directly. 20% ignore it, hoping it'll go away. And that's generally not a most effective thing. 17% call the police and only 5% use mediation. So we want to at least tip that percentage around. Is there anything in the chat we should respond to, or just people sharing?
I guess we're sharing our complaints.
And that's a very common thing, because we do share with anyone who'll listen when we've got a complaint against a neighbour who we think is a bad neighbour. And 32% of people have considered or actually moved house because of the neighbour. And we know how disruptive that can be. So we've got a few examples from mediation, the escalation and then the de-escalation. A child playing with the basketball, however, where it was set up, sometimes the ball had managed its way into next door and it rebounded off some tools that banged into the car, and he got quite upset. and came out and yelled abuse. And then he wanted the child to stop playing basketball. And so he put up security cameras with a motion activated siren. So every time he came out, it would start a siren going off. And then this siren was disturbing him, even though it was his siren that he put up to try and deter this child. And eventually the mother of the child got the police involved and a personal safety intervention order. Sometimes mediation occurs at that point as well. So most of the family violence or personal safety, the magistrates court, have a mediation arm that they can divert people to. We always meet individually and help them to consider the situation and ways that they may be able to de-escalate. And they were able to reach an agreement around managing the time that the child was playing the basketball, putting something up so it didn't go into the next door's garage, taking down the siren and camera, and apologies for screaming at the children, and starting a new, safer relationship as neighbours. So a good outcome, I think. In mediation, people don't generally get 100% of what they want, but because it's voluntary, they're always going to get something they agree with, as long as the mediator does their job and makes sure that it is a safe and uncoerced process. I've got another example, which is a really common noise complaint again. So the musician, going to be a rock star, late night practice sessions in his garage, a classic garage band. Next door neighbour, a shift worker, has early shifts, so needed to get up at 5 a.m. and wasn't getting to sleep. Rather than talking to the neighbour, who he thought looked a little bit scary, went straight to noise complaints to the council. Things deteriorated. Both felt like they were under siege in their own house and really uncomfortable. So with mediation, they reached an agreement. So take the amp out after a certain amount of time, not so loud, and stop making complaints to council and making threats to call the police and that sort of thing. So again, things settled down and started to improve. They're probably never going to be best buds, different generations and belief, but able to live without feeling so uncomfortable about where they lived. Just a couple of examples of that power we see in early intervention. We'd really like to see it happen a lot earlier in the process, and that's some of what we've designed the program that we've developed. It certainly prevents escalation, so saves council resources. A lot of councils don't have the resources to do much, and they'll try and refer people off to mediation. Sadly, some of the really brilliant community mediation programs that were in place have been closed down by short-sighted governments. Oh, sorry, did I express my opinion there? I may have, because they have been very effectively, and the cost benefit of them was well and truly proven. It certainly reduces legal and emotional costs if people can get into mediation early. Keeps communities connected. Often conflict ignored can become conflict entrenched. Conflict is inevitable in all sorts of environments, but it's the resolution that can make a really significant difference. Just in case we have anyone here who isn't a mediator and doesn't know what mediation is, for International Mediation Awareness Week, very briefly, it's a process that's facilitated by an independent, neutral mediator that helps people to clarify the issues. Often there's a lot of misunderstanding and cloud around what the actual issue is, share their perspectives, generate options for resolution, and reach voluntary agreements. And maybe over to you, Rebecca, if you want to just highlight some of the boundaries that we have as mediators.
So mediation is confidential. When you take something to court, as we know, we've just looked at a couple of court cases, that is out there for the public to see. So maybe you're going for a job, your name is attached to this judgment, and you've been a hoon, backfiring in front of the council. Basically, your business is out there. People can make a judgment about you based on what happened here and your behaviour. With mediation, it's confidential. None of that has to be aired in public.
Yeah. Also, if you make offers or proposals, it can't be used later. Well, you said in mediation that, and now we're in court, you're not agreeing to that. That you can't be held to. Yeah.
There are some things about that. So, for example, you have the mediation agreement.
Oh, yeah, if you reach agreement, that's different. Yes.
And then that can be enforced.
Certainly considered.
If an offer is made that was agreed to, so we're back to the agreement, and then you go, no, I reckon I can get something better in court. Regret being nice, or I regret even giving a little bit to you. And bad feelings have come up again, and actually I'm going to take this to court. Now the law can say, oh, you were actually partially responsible for this issue. It wasn't all the other side's fault. You were actually contributing to this as well. The settlement or the decision at court hasn't actually given you anything substantially better. So we know this because we have this agreement here. You now have to pay the other side's court costs. Yeah. Because this was a waste of time.
That applies in various jurisdictions. So if you are making an agreement, it's important to understand that is an agreement and you're meant to commit to it. So, don't agree, say, oh, I'll just agree, but then I'm not going to do it. That's really bad. Your mediator should be really encouraging you. If there's something you don't think you can do, say it. Be open about what you think is and isn't possible.
I think that just comes back to mediating in good faith.
Yeah.
So you really can't be intending to go to mediation and then at mediation threaten to take them to court. You're basically just holding them hostage, and you're not really wanting to see what the other party's side is. You're not really wanting to see what their needs and wants are. You're not even trying to compromise. If you do decide later on that court is actually your best option, there is still scope for that. Like, not to demonize court, sometimes mediation isn't appropriate for some reason, for whatever the case is. But at the time that you decide to go into mediation, have good faith, do it with the intention of being genuine in it. So I'll just keep going, Joanne.
Yep.
Mediation is accessible. We do online mediation as well. If you don't want to do it online, there are meeting places that can be agreed on by everyone. It's safe. So yes, the mediator does go through a screening process to see what is appropriate. For example, you are allowed to bring a support person if everyone agrees that you can bring a support person. You can bring your lawyer if I agree that you can bring your lawyer. And if you bring your lawyer, I'm going to bring my lawyer, and we're all going to agree to bring our lawyers. And the mediator who is screening everyone might think, these lawyers, I don't think they're going to help the mediation process. But if a lawyer happens to be interfering in the process of the mediation, the mediator can say, no, you're not invited to the mediation because you're proving problematic. And then everyone can discuss who can actually be there again. So it truly is voluntary in that sense as well. If you don't like the support person that the other party wants to bring, you can say, no, they don't have my permission, and then that's fine. And everyone can say that to each other, yay or nay, to whoever you want to bring. Yeah. And that also goes into safety, because the mediator wants the mediation to be successful and also wants it to be safe. If you don't feel safe, how are you going to negotiate effectively, and how are you going to genuinely come to an agreement that you would actually want to keep? So that comes from a feeling of safety. You're going to have to speak to this, Joanne, about the effectiveness.
The majority of cases, so it's not easy to get data, but around 70-80% or higher of cases do resolve in mediation or shortly after. It has a much better than even chance of success. We can't guarantee that for your particular situation, because ultimately you're the ones making a decision about what success is and whether you're willing to agree. The other key point is that a mediator should be independent. Sometimes people get someone who's nice or helpful to mediate, but if they're not trained to be neutral and independent, you may find that it's actually not a mediation process. It's someone coming in to try and persuade you. So be mindful. I'd always encourage, if you're going to use a mediator, make sure they are nationally accredited. There's a national register of mediators who are qualified, trained, and maintain ongoing professional development. A bit of an idea on how we work at ICDRS, Interact Community Dispute Resolution Service. We offer a pro bono mediation service for neighbour disputes, trees, fences, noise, all of that sort of stuff. We have means tested some other mediation services, generally within community mediation services. If people are on a low income, then the intake process is free, and we'll work with you to work out what fee, if any, you can pay for the actual mediation. And of course, all of our mediators are trained and accredited. We often run a co-mediation model, so two mediators working together and supporting each other. Sometimes the mediators are newer. They might have recently become accredited, and they'll usually be working with someone who's got a lot more experience that's volunteering their time as well. So, in referral pathways, you can self-refer via our website. There's a form there that you can use. Council, local government, courts, community legal centres all refer through and can. We're very happy. And we have our phone and email support. We are a virtual service, which means we're real people, but we don't have office overheads or anything like that. People are working with us from all over the country, volunteering a little bit of their surplus time to be on our panel, which we are very grateful and thankful for all of our wonderful people. So that's a little bit about how we work. The community mediation is often multi-party because within a community group and organisation, it's kind of a little bit contagious. Conflict tends to escalate quite quickly and everyone gets involved and has opinions about, you know, who's right and who's wrong. And they're often interpersonal disputes about what people think is appropriate or not appropriate behaviour. Of course, we're working within the framework of bullying and discrimination legislation, and if it's illegal behaviour, then that would be screened out and go into an appropriate process. But ultimately, the big benefit is that people can contact us, find out, and we can assist with that triage process of working out the best approach. Sometimes people need urgent legal advice and we'll advise them that's the case. We won't provide legal advice, even though we have lawyers working with us. They're working as mediators. It's really important that people understand mediation isn't a process where people should be uninformed in making decisions. We're very happy to accept referrals from community legal centres, local councils, and establish a more robust and easier to refer process. We run a Ask a Mediator callback service. So basically, it's a free service. Anyone can make an inquiry, fill out a little form, one of our team will call them back and have a chat. It might result in saying, well, look, this sounds like something that might be suitable for mediation, and they move on to pre-mediation, which is a more structured individual meeting with each of the people involved, and then if that proceeds, they'll go to mediation, or it may be that they refer them on to some other service or process. There's a page on our website. So if you are from a community organisation, local government, or anyone that has inquiries from people in conflict, and then we're happy to look at putting pathways in place. We have some with organisations where the benefit is that we learn the organisation culture, processes and such, and we fit in within the dispute resolution process. This is our website. We have an inquiry form and we'll pop the links down there. Ultimately, Interact supports a not-for-profit. Our mission is to prevent abuse and violence. We see the use of mediation, the promotion of mediation to get people very early as we possibly can, when they just don't feel like they can speak directly without that extra support, in order to prevent that escalation into either taking it into their own hands so that the police come around, or ending up in an adversarial legal battle with lots of costs. I'm sorry, I got on a little roll there, Rebecca. Anything final wanted to add?
I just also wanted to add something to do, you know, as you had mentioned before, the role that the media has to play in the there's ethics involved in being a mediator and some things we have to consider. And there are a few principles that a mediator does have to balance. So while we are neutral, and we're expected to be neutral to allow the parties to have the autonomy to decide between them, we also have to manage power imbalances, which I also discussed, like I touched on before, regarding safety. There are other things that we do as mediation is sometimes used as, by magistrates, by judges, as a way of resolving a dispute instead of court. So yes, you think you're going to court, and then the magistrate will say, no, you're going to mediation. Yeah. it is also in mediation that we try to find a fair and reasonable outcome for everyone.
Yeah.
So it's really not just, okay, we're just going to agree and just give up, or okay, fine, I'll let you have your way, and I can't be bothered dealing with this anymore, and I'll just let them have their way. I'm going to give in. That's not necessarily what you'll get, and that's not what the mediator wants for you either. The mediator doesn't want conflict to continue. Maybe it'll change the way that it looks in the future, depending on, and then even when you have your first mediation and some kind of agreement is made, that does pave the way to have future negotiations just between the two of you, because now the ice is broken. But yeah, because it is literally alternative dispute resolution, the aim is also to find a fair and reasonable outcome.
Yeah.
So that's
It's
something
not
else.
absolutely. No, that's a wonderful thing to point to raise at the end. So it's not peace at any cost. It's a positive piece. It's finding a way that's going to work for both. And in the mediation process, we where we can, we get people speaking directly, but we use a process called private sessions where we'll bring people apart and check in, and think you seem to be, if people aren't speaking up, to find out what's going on for them.
It is a red flag, isn't it, Joanne, when someone doesn't want to, they look like they're shutting down.
Yeah.
They look like they're giving up. And then that is also a red flag. It's not like the media just wants the mediation done.
Yeah.
Yeah.
Oh, absolutely. And look, often, I guess that's one of the other big advantages of mediation as well, because often we have people who may have mental health issues, or they may have physical issues, where spending a long time might be too much of a burden. And so we need to do a couple of short sessions rather than try and have them there for a very long time, because they just physically are not able to focus for that long.
Yeah. And you do, I know ICDRS does screen.
Yeah.
Or accessibility, like we mentioned before, anything that they need for the
But so we're trauma informed, and we're client focused. We ask them, this is what the standard process would be, 3 hours. How will that be for you? And they say, oh, I couldn't. I've had one recently where even doing the intake, we had to break it up into a couple of sessions of their health. So
something to add as well. I'm just wondering, because I mentioned the autonomy and that we appreciate and respect client autonomy for both parties, that they have to speak for themselves and come to agreement themselves. That doesn't mean the mediator is sitting there like a referee saying, okay, now everyone just behave themselves. There's a lot more to it. There's a lot of heading off at the pass, certain, when we can tell that the way something has worded is going to inflame the other party. We do a lot of reframing. We do a lot of reality checking. What else, Joanne? What else what other magic can we do in the session?
There's a lot of skills. We do a lot of summaries, like we gather up the information into little parcels so people can see it, because often people, sometimes they're actually not that far apart, but they're speaking across purposes and not hearing each other. And there's often a need to rebuild trust and look at, it's not just the practical thing of the tree or the yelling, and the other things that have happened need to kind of be healed a little bit. We're not doing counseling, but giving people a chance to kind of turn the page over, I suppose. And
there's with the reality checking, we may ask questions that the parties don't even think to ask. That does affect how the agreement will move forward in future. So those things can come up, and it's a good thing that there was another person there, to think of these things. We can be quite rigorous, regarding the practicalities of the agreement. Because you might agree in principle to something, but then how are you actually going to decide how to do it? Who's in charge of what? When will it happen? These sorts of things. And then you don't want the clients or the parties at the end of it going, oh, no, we haven't really decided anything in substance. I guess it's a rigorous process.
Yeah,
Yeah.
absolutely. That's a really important part of having a professional mediator, because it's not just like a head at the high level agreement. It's, well, how's it going to work? So who's actually going to do that? Who's going to get the quote? Who's going to, what do what if there's a big difference in the number, in the value of the quotes? How are you going to decide which one to go for? All of that sort of things, if it's a practical thing like a fence issue. I just, now that I'm not sharing the screen, I was able to have a look at the chat, and I see Damien shared that, yeah, sometimes the courts have a mediation process that's free or very low cost, and that's fine. We're not planning to do every mediation in the country here. Our goal is to help people that are falling through the gaps, that don't have access to an affordable for them process, to help them to discuss with someone who they've got issues with. Oh, we've got someone who was a CJC mediator. Yeah, such a wonderful program, and so sad what happened. Yeah. So, any other final thoughts or comments?
I'm just curious about Damien's neighbour who went to small claims for their dog bark. So they were actually able to quantify, or to get from small claims court, a monetary amount for the dog barking in the trees. So I'm just curious about Damien's story, if he's still there, if he can answer.
Oh, they didn't end up going. So yeah, they might have realised that it wasn't going to give them.
Okay.
Yeah, so that's the other. Yeah, there's a formality around courts. Courts have got a remit. They've got a certain range of things that they're able to do, and that's as it should be. So sometimes it's a little bit of a challenge to find that demarcation. But yeah, there are community legal services and others, legal aid, if people are eligible, may be able to assist, but not with everything. Sometimes it can be advice, but not further than that. Yeah, so any other thoughts or comments? We've actually used up all our time, Rebecca. No,
Which works if no one has any further questions.
Otherwise, yeah.
I'd love to answer any questions if you have any.
No, well, hopefully that's helpful. If we do have any mediators who are interested in being part of our program, you're welcome. Please go to the ICDRS website and you'll see some information about joining the team. We've got our Interact support, which is the not-for-profit. We run, ICDRS is one of our major programs. We also have a family dispute resolution program called Interact Online. So they're our two major projects. And we have our AGM coming up. If anyone's looking for a board position, we'd love to bring some new people on. So feel free to get in touch. And if you're watching this on recording, you can get in touch anyway, and I'm sure there'll be a way to engage with us. So thank you, everyone. I'll turn off the recording. Any final word from you, Rebecca?
No, I just appreciate everyone being here. Thank you so much.
Thank you so much.
Thank you. I'm sorry, I got on a little roll there, Rebecca. Anything final wanted to add?
I just also wanted to add, as you had mentioned before, the role that the media has to play. There's ethics involved in being a mediator and some things we have to consider. There are a few principles that a mediator does have to balance. While we are neutral and we're expected to be neutral to allow the parties to have the autonomy to decide between them, we also have to manage power imbalances, like I touched on before regarding safety. There are other things that we do as mediation is sometimes used by magistrates, by judges, as a way of resolving a dispute instead of court. Do you think you're going to court? And then the magistrate will say, no, you're going to mediation. It is also in mediation that we try to find a fair and reasonable outcome for everyone. Yeah. So it's really not just, okay, we're going to agree and just give up, or okay, fine, I'll let you have your way, and I can't be bothered dealing with this anymore and I'll just let them have their way, I'm going to give in. That's not necessarily what you'll get. And that's not what the mediator wants for you either. The mediator doesn't want conflict to continue. Maybe it'll change the way that it looks in the future. Even when you have your first mediation and some kind of agreement is made, that does pave the way to have future negotiations just between the two of you, because now the ice is broken. But yeah, because it is literally alternative dispute resolution, the aim is also to find a fair and reasonable outcome.
Yeah. Yeah, so that's a wonderful thing to point to raise at the end. So it's not peace at any cost. It's a positive peace. It's finding a way that's going to work for both. And in the mediation process, where we can, we get people speaking directly, but we use a process called private sessions where we'll bring people apart and check in if people aren't speaking up to find out what's going on for them.
It is a red flag, isn't it, Joanne, when someone doesn't want to, they look like they're shutting down. They look like they're giving up. And then that is also a red flag. It's not like the media just wants the mediation done.
Absolutely. And look, often, I guess that's one of the other big advantages of mediation as well, because often we have people who may have mental health issues or they may have physical issues where spending a long time might be too much of a burden. And so we need to do a couple of short sessions rather than try and have them there for a very long time, because they just physically are not able to focus for that long.
And you do, I know ICDRS does screen, accessibility, like we mentioned before, anything that they need.
We're trauma informed and client focused. We ask them what the standard process would be. 3 hours, how will that be for you? And they say, oh, I couldn't, I've had one recently where even doing the intake, we had to break it up into a couple of sessions with their health. So
I'm just wondering, because I mentioned the autonomy and that we appreciate and respect client autonomy for both parties, that they have to speak for themselves and come to agreement themselves. That doesn't mean the mediator is sitting there like a referee saying, okay, now everyone just behave themselves. There's a lot more to it. There's a lot of heading off at the pass, when we can tell that the way something has worded is going to inflame the other party. We do a lot of reframing. We do a lot of reality checking. What else, Joanne? What other magic can we do in the session?
There's a lot of skills. We do a lot of summaries, like we gather up the information into little parcels so people can see it, because often sometimes they're actually not that far apart, but they're speaking at cross purposes and not hearing each other. And there's often a need to rebuild trust and look at, it's not just the practical thing of the tree or the yelling, and the other things that have happened need to be healed a little bit. We're not doing counselling, but giving people a chance to turn the page over, I suppose. And
with the reality checking, we may ask questions that the parties don't even think to ask. That does affect how the agreement will move forward in future.
Yeah.
So those things can come up, and it's a good thing that there was another person there to think of these things. We can be quite rigorous regarding the practicalities of the agreement. You might agree in principle to something, but then how are you actually going to decide how to do it? Who's in charge of what? When will it happen? These sorts of things. You don't want the parties at the end of it going, oh, no, we haven't really decided anything in substance. It's a rigorous process.
Yeah, absolutely. That's a really important part of having a professional mediator, because it's not just a high-level agreement. It's, well, how's it going to work? Who's actually going to do that? Who's going to get the quote? What if there's a big difference in the value of the quotes? How are you going to decide which one to go for? All of that sort of things, if it's a practical thing like a fence issue. Now that I'm not sharing the screen, I was able to have a look at the chat, and I see Damien shared that sometimes the courts have a mediation process that's free or very low cost, and that's fine. We're not planning to do every mediation in the country. Our goal is to help people that are falling through the gaps, that don't have access to an affordable process, to help them to discuss with someone they've got issues with. We've got someone who was a CJC mediator. Such a wonderful program, and so sad what happened. Any other final thoughts or comments?
I'm just curious about Damien's neighbour. who went to small claims for their dog bark, they were actually able to quantify or get from small claims the monetary amount for the dog barking in the trees. I'm curious about Damien's story, if he's still there, if he can answer.
Oh, they didn't end up going. They might have realised that it wasn't going to give
okay.
courts a remit, a range of things they're able to do, and that's as it should be. Sometimes it's a challenge to find that demarcation. There are community legal services and legal aid, if people are eligible, may be able to assist, but not with everything. Sometimes it can be advice, but not further than that. Any other thoughts or comments? We've actually used up all our time, Rebecca. No, you.
Which works if no one has any further questions. Answer any questions if you have any.
Hopefully that's helpful. If we have any mediators interested in being part of our program, you're welcome. Please go to the ICDRS website and you'll see some information about joining the team. We've got our Interact support, which is the not-for-profit. We run, ICDRS is one of our major programs. We also have a family dispute resolution program called Interact Online. So they're our two major projects. And we have our GM coming up. If anyone's looking for a board position, we'd love to expand bring some new people on. So feel free to get in touch. And if you're watching this on recording, you can get in touch anyway, and I'm sure there'll be a way to engage with us. So thank you, everyone. I'll turn off the recording. Any final word from you, Rebecca?
No, I just appreciate everyone being here. Thank you so much.
Thank you so much.
Thank you.